technical issues in disruptive technologies, something of a session that is so close to our hearts. I'm sure there's going to be a lot of intense discussions, a lot of questions, more questions than answers. So in this outlandish information superhighway and in this age of disruptive technologies, we try to put through a very, very good session, very interactive session, which promises to be though. Can I call the following dignitaries on stage, please? Can I have Rakhi on stage, please? Ms. Rakhi Jindal, Senior Vice President, Operations and Technology and IP Law Group at Citi. Coincidentally, she is also the co-chair of this conference. One round of applause for the wonderful co-chairs, please. Rakhi and Aditi have been able to put up a very impressive program and harness some of the best law talents in the country for this conference. So Rakhi on stage should be joined in by Ms. Kavitha Babu, Director and Commercial Attorney, Microsoft India. Thanks, Kavitha, for joining us once again this year. Can I also have Supratim Chakraborty? Thank you, Supratim, for your support. Associate Partner at Khaitan and Company. Mr. Blake Brannon, thank you, OneTrust, for supporting this conference. May I have Mr. Blake on stage, please? Vice President, Products at OneTrust. Can I also have Mr. Sivaram Nair, Executive Vice President, Company Secretary and General Counsel, and the Ethics Officer at Mphasis. Thank you, Sivaram. Kanchan, we must have you back on stage. Kanchan Paralkar, Legal and Governance Officer at Tata Insights and Quants. It's part of the Tata Industries Group. And we have N.S. Nappinai. Nappinai, leading advocate and author of Technology Laws Decoded. I feel very privileged because there are so many lawyers I've been working with for the last 13 to 14 years. I know whom to fall back on when I'm in trouble. So Nappinai is one of those lawyers, hopefully. Before we start this panel, the keynoter got a memento, a book called The Technology Laws Decoded. And Nappinai is the author of this wonderful, big, fat book. Why don't you spend a minute with the audience and tell them more about the book, and then we can start the session. Yeah, just a minute.
Thank you, Devi, for such a lovely introduction. And we have a very large panel today. So if possible, I'm going to take even less than a minute to talk about the book. I can just say that, today's topics and discussions that have been put together is a reflection of a lot from what I've written in the book also. It's a beautiful combination of topics. But most significantly, if you see the thread that runs through the sessions through the day, there is a interplay between multiple subjects which we may not even have linked together. This is one instance, this current panel, and the next one where we are discussing about antitrust and privacy. So in effect, what the book talks about, and I am going to capture it in just a couple of lines from the book itself. I hurriedly put it together when Devi sprung this on me. The book starts off with these words: law in the world of the internet is a constantly changing and evolving beast. It neither has parental guidance nor memory genes to guide its path to the lighter horizon. I was a turtle walker, so for me the lighter horizon to which the turtles move was a very important concept which I've tried to bring here. I've explored in the book every aspect that I have dealt with over the last 17 years of teaching and practicing in this field, of not just cyber laws as a standalone subject, but as an interplay between multiple topics. So the book ranges from its a foray into technology and the way the Constitution has been reinterpreted to meet this challenge. Of course, the evolving field of cyber crimes, IPR and technology as a completely different field as opposed to just pure IPR or intellectual property rights. And of course, the field of contracts. I think a lot of it was discussed in the last session. A very important point was brought up about the conduct or result, which I would like to address during the panel, because I don't want to take up too much time at this juncture. But that's been dealt with. I've also talked about the broken windows in cyberspace because I firmly believe that whatever we may discuss over here, whatever the laws or policies or regulations, including self-regulation that companies may put in place, unless these are implemented, unless there is enforcement of these rules or laws or guidelines, it's not going to be effective. So this is the concept that I have explored in the last chapter. So with this and with these words, I would like to hand over back to Rakhi. The world of the internet has been, looked at as something which has been born without any kind of restraint. It's a world which has grown exponentially without restraint, and I've drawn from Chomsky's utopian concept of liberty there, a space where intelligence, dignity, and human happiness can develop and grow without the restraints imposed by formal liberty, which is conceded, measured out, and regulated by the state. Cyberspace was not Chomsky's eternal lie representing the privilege of some founded on the slavery of the rest. Today, and probably a lot during this session, we are likely to discuss about the slavery which we have subjected ourselves to with our dependence on this domain. But with the benefits come a lot of strings. Let's move on to discuss more about the strings that are attached, particularly with respect to privacy. Thank you all, and thank you, Devi, for this opportunity.
Thanks, Nappinai. To start the session, our session today is on the legal and ethical issues in disruptive technologies. That is a very wide and a very interesting topic, sometimes relegated to the background. But history is witness to the fact that whenever we've had anything disruptive, starting from the Industrial Revolution, which mechanized labor, down to our foray into space, the final frontier, it has always benefited humanity. Our knowledge has increased by leaps and bounds. Physical labor has decreased, which has presumably advanced the quality of our lives. But on the flip side, as with any good thing, there is always a looming shadow, a looming darkness. There are fears that disruptive technologies and the way the technology is improving day by day, it could lead to some very real concerns, such as, do we ascribe the same humanity and the same morals to machines? When with all the advances in medical technology and in gene mapping, are we trying to emulate God? And most importantly for our conference today, with all the division between our private life and our public life is slowly eroding, so are we becoming less private? Is our privacy being less respected? And what have you. So with this background, we have a very professional and a very experienced panel with us. And we will try and deal with as many technologies and processes as possible, but I don't think we have enough time. So we will deal with some of the key processes and technologies, and we'll leave and we'll open the house for questions. I will start immediately with the questions. First question again is for Nappinai on artificial intelligence. As you mentioned, AI is everywhere. We have voice recognition, we have driverless cars, we have everything to do with AI now. Traditionally, if software did not work, we would pin liability on the software developer, or we would pin liability on user negligence. But AI is more dynamic, and it depends on machine learning to a large extent, which is uncontrollable. So is law able to keep up with the advances that AI is making?
Very, very interesting question. Thank you, Rakhi, for that. Again, I would like to draw a little bit from my book on this. I have kind of rephrased thorough to adapted to technology. And this line I felt really answers the question bang on. Technology may be propelling us into a new century with no plan, no control, no brakes. And I have just cautioned in the book to say that probably it's now time for us to reprise control before we cross the fail-safe point. So, from a lot of these Hindi movies, you can remember this car which is hurtling down towards that precipice. We are almost there. But like you rightly said, technology is also something that you need to embrace. You can't possibly run away from the benefits that it gives. It's very interesting with respect to automation and AI, which is where it has had its maximum exposure globally. Where the laws or regulations are moving is in trying to distinguish one between learning and self-learning. So what they talk about is artificial intelligence which has been implemented in a system, an automated system, before it is sold to the user. So there, a lot of AI has already developed, it has learned, and up to that point of learning is implemented already. So the manufacturer has some control over the process. Self-learning is the continuation of that learning beyond that implementation. Now the difficulty, and it's very interesting, Germany has conducted a research on this, and they have discussed about how when a car, for instance, is sold to a customer, the assumption is that every Tesla car would remain the same. But with artificial intelligence, what effectively happens is a car is sold at a stage where it is uniform, but then with artificial intelligence, depending on the driver's ability, the user's interface, and their effective usage of the technology, the learning parameters will differ. So the same product becomes a different product for different people in no time. So in effect, what they're trying to say is to say that it may be too premature to put in self-learning AI beyond the sale, but you use AI up to the point of sale. So this is one of the aspects that has been explored. Again, it's an open-ended issue. Considering the kind of things that we have seen when we talk about automation and AI, and I will just give a few examples to just get the thought processes going. Of course, we have the cases of cars crashing, cars burning away, 2014 to 16 to even recently, Tesla included, have had their mishaps. One instance which always comes to my mind when we talk about AI is of the Boeing airliner, which said that, we talk about software and we say that there is no software which can run without bugs. Now, the Boeing airliner had a very strange bug, Dreamliner, sorry, had a very strange bug which said that if you have not switched it off and switched it on after some 285 days or something of use or hours of use, it will automatically shut down. So the whole issue became about how the AI is going to just shut your flight down and you don't even know when it's going to happen.
Thank you for your views. Moving on to Sivaram, a point on robotics. To advanced robotics promises a world where there is less physical labor, and it promises a world with better quality of life for possibly marginalized people, where we can have exoskeletons which help physically challenged people move around. What are the ethical issues that you're facing or that the industry is looking at in the space of robotics?
Correct. Yeah, the advantages which you said on robots, it's very clearly evident, right? Lesser time, lesser cost, quality consistency, higher productivity. There are many challenges from the ethical side. Let us take some of them. One is disparity in wealth. We are seeing it, right? Robots replacing people, and usually the lower strata people, and the governments have to be attending to the economic, socio-economic impact which creates. Even in the IT industry, you would have seen now we talk about forming unions, going to the courts. Earlier, they were the king, now it has completely changed. Automation, replacing employees. The second one is very interesting, which is disuse atrophy. What happens when you don't use your muscles? If robots, as you said, robots do everything what human beings done, you will lose your physical activity, mental activity. The result can only be more Alzheimer's, more depression, nothing else. Okay, the third is impact on global warming. Abundance of everything at cheaper cost will surely lead to a aggravated global warming. Robot self-learning, which is very dangerous, right? What we saw, the machine learning taking it to the next level. We had last year, the judge was a robot in a beauty context. And what happened? There was a clear bias against dark-skinned women. They went back to the criteria didn't put anything of that sort. Now they are saying that the coder would have had some personal bias, not explicitly written, and the machine takes it to the next level. Very dangerous. Facebook had, if you know, a new language coming, they had to shut down immediately, which was so unintended consequences, undesirable, very dangerous. Morality in decision making. Now that, Nappinai, as you were saying, in a driverless car, right? Suddenly 5 children come in front of the car and 1 passenger inside. Would the car save the passenger or the children? But interestingly, a month back or something, there was a test done on one of the driverless car, and the situation is, there is a motorbike, there is a bigger vehicle, and the car has to be hitting one of them. It was found that the car went and hit the motorbike, which means it's always trying to save the passenger inside, thinking that he is the owner. So all these ethical things needs to be taken care of. And the last one is the threat of being hacked, right? If everything becomes digital, coded, there can be somebody who can misuse it by running an algorithm, no, which would not give, like a driverless car. You want to go to X place, it will go to Y place, and consequences can be different. So all that. I think I would stop over here. There would be many more unintended consequences on this.
Thanks, Sivaram, for that snapshot of the ethical issues. Coming to Kavitha, on cloud computing, the whole premise of cloud computing is that the data is not stored locally and it's stored in the cloud. And there are a number of service providers who may be involved when we talk about cloud computing. This results in a situation where the user does not have control over the data. The user does not even know what sort of privacy philosophies and policies the various service providers in the ecosystem follow. And this sometimes results in customers saying, we don't really trust the cloud. So have you seen that in the industry, and what is it that the industry is doing to allay these fears?
So the father of quantum physics, Niels Bohr, said that predicting is difficult, especially about the future, right? But one thing's for sure, and if you have to believe the Gartners of the world, cloud computing is here to stay. It has been for a while, but it's here to stay, and every business of the future is going to be a digital business. In fact, there is statistics to show that 90% of the apps or solutions that will be developed by the end of 2018 is going to be natively built on the cloud. So it's not a matter of when it is happening around us, right? But you still raise very, very valid questions, because the environment that this technology subsists in is complicated, especially from a regulatory standpoint. You have laws around privacy and security that are changing dynamically. Positions that have long been held can be, written away by a pen stroke. And the example of that is what happened with the safe harbor provisions between US and Europe. And you have new laws, complex laws, and that are being implemented. GDPR, for example, laws that are yet to be implemented as an outcome of the Supreme Court judgment here in India. It is a complex landscape, and when you're running a global business, all of these intersect and make it even more difficult for people in this room, which I'm assuming most of you are lawyers, for to do your jobs. But the fact is that you're expected to be experts on privacy, and you're expected to also be able to advise your boards about risk-taking, etc. So there are questions that you need to ask your cloud service, when you're using solutions that are based in the cloud. There may be applications that may be resident on your premises. They may be, in your premises, and you think that you have control over it. But they may also be built on infrastructure that is based in the cloud. And so when you're trying to pin or when you're trying to find one throat to choke, it can be a challenge from a customer standpoint, right? So it's really, really important to understand what are the right questions that need to be asked. There is a responsibility, therefore, as an industry, to make sure that we have standards that are dependable from a privacy standpoint. And there are well-established international standards that are developed on privacy in the cloud in the form of ISO 27018 that define some very stringent set of extremely, there are almost 1,600 plus controls in the standard. And so the hope is that when in the absence of laws, if the industry actually self-regulates itself against these very, very compelling, stringent standards, we will create an ecosystem where the expectations from the customer are high, and that every player, if he has to be relevant in the cloud industry, will have to sort of answer to those controls as well. So the answer, as lawyers, we tend to sort of really limit our conversations to limitation of liability. Can I, who will indemnify me when things go wrong? I think it's time to sort of elevate that conversation and elevate that discourse. It's important sort of to recognize that there are multiplicity of players and be able to also identify what the responsibility of each of those players are. And that could be a combination of, applications, providers, the cloud infrastructure providers, and you as a user yourself. There are responsibilities around privacy and security and controls that reside at each one of these levels. And so it is, we're all in this marriage together. And just pushing the buck from one to another is just not the way to address it. But at the same time, holding every player, in every cloud technology provider responsible for what they say that they are going to do, not only in terms of expecting them to share, say, the reports of the audits that are conducted by third-party agencies against these stringent controls, and also documenting their commitments in the contracts that they sign with you. So these are all sort of the questions that as lawyers we should be asking. In the absence of, regulation, say, in the Indian market. But it's only a matter of time.
So self-regulation and accountability in the place of regulation, that's very interesting. Going to Kanchan from the big data industry. In the world of data analytics, it is really the collection and the processing of data and personal data on which big data thrives. When we're looking at the development of the data analytics industry, we read about differential privacy methods and differential privacy policies which the players are adopting. Can you tell us something about it? Can you tell us whether these differential privacy policies and methods are actually helping, and how is the industry looking at it?
Sure. The day by day, companies are realizing the value and the potential of data. But considering that the Indian laws are not that developed and the limitations that are attached to, how you can use and the purposes for which you can use data, companies do want to maximize on the potential that the data sets can offer to them. So companies these days are adopting techniques such as anonymization and several differential privacy techniques, which then help them to utilize this data to be able to service their customers better, make their products better. And I would say to a certain extent it does help companies because they get to learn a little more about the customer. And these differential privacy techniques actually help you to get closer to the customer by generating, insights using anonymization techniques and learning a little more about, how best they can position themselves to be able to market their products better, to be able to service their customers better without actually disclosing the identity of any individual. So And whether it is being effective, it all depends on how robust these systems are, because the algorithms that are run to actually generate insights out of this data depends on how effective these algorithms are and to what extent the privacy is being maintained for each of these customers.
Thank you. So from non-regulated industries, I'd like to move to one of the most regulated places, which is the office, and talk about employee privacy. Supratim, there was a time when BYOD used to be a buzzword and it used to be disruptive at the offices. Today we've moved way beyond that. We have a situation where employers are tracking us through wearables, through apparently even through implantable chips. So can you talk to us about the ethics and the legality also of such practices in the workplace?
Right. So when we talk about ethics, let me give you statistics. So there are several statistics which have proved approximately 2.5 working hours every day, every employee is spent on cyber slacking, which is basically non-productive, non-work related surfing during work hours. So I think ethics applies both ways. So it's not wrong to monitor. It has been, monitoring has been there since ever. But I think what is important here is to, understand the concept of, I think, informed consent, which is now being spoken about a lot, of course, in the last session we just heard how it is becoming redundant. But I am talking about a wider universe of, informed consent, where you explain to the employees what is being done, why it is being done, so that they are on the same side as you are. It's not adversarial, really. And that's how I think they appreciate what actions are being taken and become a part of it. So truly speaking, we are not only fighting menaces such as data pilferage or IP theft. We are also talking about productivity, for which these devices are being implemented. And it's quite scary, actually. What you said is, we were doing some work, and we realized that since the year 2015, there are some institutions which are implanting microchips into the body of the employees, and you don't need a swipe card, really. That can be used for entry, exit, that can be used for buying smoothies in the premises, and so on and so forth. So one of my friends was asking that, these wearable devices are very, very, cool. What do you think could be a problem? I said, sick leaves could be a problem. Because your employer would know whether you're actually unwell or not. So the moot point here is that, blood glucose levels, whether you are stressed out on a particular day, all of this data would be available with your employer. The core question, therefore, from a legal standpoint is informed consent, and also to what extent it is relevant for the purpose for which you're collecting. So if these two things are kept properly balanced, I believe it is a good move to have such tracking measures. Of course, you should not overdo it, because in the past, some of these have been a little counterproductive. So we need to keep that in mind.
Thanks, Supratim. I'd like to move on to Blake, who's the non-lawyer and the technologist in the panel, and will surely provide us different perspective and talk about data security. We've seen so many instances in the recent past about data hacks. We had the Verizon data leakage of phone information and phone logs, and we had an Anthem data leakage of medical information. Now, in this scenario, what advice would technologists such as yourself give to your stakeholders in the company of how to process data and how to use data in an ethical and in a legal way?
Yeah, great question. So I will try to look smart amongst all these really smart people, being a technologist that doesn't have a privacy or a legal background. From a security standpoint, I think it's, to me, talking about data breaches, there's about one a day. We just saw Equifax, in the US that just happened, massive data breach. About every other citizen's data was compromised in the US. From a security perspective, the laws and physics around security of data are really kind of solved. I mean, it's really just down to statistics of encryption is encryption and it works, and there's a mathematical certainty of a probability that that can be decrypted. The problem with every sort of use of encryption is that the decryption keys are not properly stored and managed. It's kind of, I don't know what the equivalent here is in India, but every home in the US, even though we all put locks on our doors and windows, there's probably the key under the mat, the dummy rock by the door and things like that. So it's kind of the same thing with the way software works in all these companies, where the decryption key is right there in the app server sitting beside the database that has all the data encrypted. So independent of known mathematical models of here's how we encrypt and secure data, I think what's really important from the ethics, the privacy aspect, when you're looking at what can we do to help influence what companies are doing, I think it's really, three things. First off, we have to start helping educate our very smart engineering technologists that are in these companies on the importance of distinguishing between can we do something versus should we do something. And often as engineers, and I have an engineering background myself, we love to just think of really cool things we could do, but it doesn't necessarily map to something we should do inside an organization. So I think just the general awareness of thinking about that inside a technology company is key. Additionally, companies really need to understand what they actually are doing, and you'd be amazed at the gaps that we see in the market where companies are just unaware of the information that they're even capturing, the type of processing that they're doing. And some of it comes from, code that's put in by a really smart engineer that's trying to get better insights into how someone's using their application or tool, so they add a little piece of software. That should be thought of as malware inside your code base. If you don't know what you're actually doing and capturing and documenting, you should consider that a virus inside your application. I think things like BYOD are another great point of where shadow IT has just taken the industry by storm, and companies don't really understand all the little apps, the file servers in the cloud that their company is using, where they've copied data over to it, and things like that. So being aware of what you actually are doing, what data you have, is key. It'd be really bad to end up on the front page of the Wall Street Journal with a data breach for some information that was compromised, and you're not even using it to benefit your bottom line as a business. You just had it on the shelf and you weren't even processing it. And then the last thing I would say that's really important is transparency to your customers in the market of the way you respect data protection and the information that you have. I think a great example of this recently was Apple kind of announcing Face ID. And during the keynote where they talked about it, they talked about the security, here's how it works, here's how great it is and how beautiful it is and how secure we make the data, and it's secure. But they never really talked about what they did with that data and where it went. And it was almost like an uproar within the next 24 hours from the internet of people kind of being very concerned, and now they immediately are kind of reacting and saying, we're going to publish a white paper that talks about how we're using this information, where it's stored, and things like that. So I think, everyone gets that the world's not perfect, breaches will always happen, but if you are being very transparent as a company on here's what we do with your data, here's how we respect your personal information, and we really are always weighing the benefits over the risk, I think you'll get a lot of credibility, if an incident does happen.
Thank you. I think, yes, transparency and engagement are quite key in these situations. Coming back to Kavitha, when in the cloud services scenario, when the service that you're actually providing to your clients is really a movement of data seamlessly across borders, across countries, it is obvious that there will be some sort of influence and engagement by different governments, by lawmakers, and also by the users and the cloud service providers. Can you tell us a little bit about this engagement between different parts of the public and the private?
So in the context of security, I'll give you examples that, as Microsoft as a company and our philosophy on this. So we believe we are, as a cloud service provider, we're custodians of our customers' data, right? We can never be the owner of that data. The owner of the data is the one who's able to control the data. The distinction that I want us to understand is there's a perception in the market that once you've handed over your data to a cloud service provider, that you've lost control. If you've actually lost control of the data, then you're probably not engaging with the right kind of cloud technology. What as a customer you perhaps could worry about and ask relevant questions about are questions around, obviously because you don't have access to the facilities that the cloud service provider runs, right? You don't have access to the infrastructure, but the data is still yours. And every cloud service provider should be able to give you that assurance that it is you who will determine how and who accesses that data, how that data is going to be used, for what purposes it will be used, and when you want to withdraw that data, and when you want to be able to do anything with that data is entirely in the hands of the customer. Now, that being the scenario, I think as members of the industry, it is incumbent on technology companies to stand up when governments have overreach, right? When governments are actually trying to bypass traditional routes and are reaching out to this cloud service provider instead of actually reaching out to the owner of that data when they want access to certain data, it is absolutely imperative that the members of this industry need to stand up and say, one, have you employed due process in defining how you want, have you employed due process in actually seeking that data? And is there an overreach? And when there is, we have to stand up and say no. And Microsoft has done this. We've actually challenged the US government, not once, not twice, but 4 times, and successfully so. And I can give you a couple of examples where we fought for the right for our customers to know when governments have made requests for data. We believe it is absolutely critical to just supplement Blake's point. Transparency is key. Without transparency, customers will not trust us. And if you don't trust that technology, customers will just simply not use it. So we stood up for the right to actually be transparent to our customers if the government ever sought their data. We think it's absolutely important to have that trust with our customers. And another landmark case where we fought the U.S. government against a search warrant that a federal court actually issued against Microsoft in India because the U.S. government wanted access to email of a non-American citizen where the data was actually resident on one of our data centers in Dublin. We resisted this. While they had issued a search warrant, so they had, technically followed due process, but we believe that search warrant was absolutely incredulous. I mean, it was not properly issued because it was, again, overreached by the government and not employing the procedures that are already in place, because our belief was that the US government should have gone straight to the Irish government using existing international mutual legal assistance treaties and then sought that data and not gone through the government. So we're proud of what we do in the industry because we're creating leadership in the industry, and that has a cascading effect. And so when Apple stood up against the government in the light of those horrible terrorist shootings in San Bernardino in California, what the government was asking of Apple was really would have completely compromised the very security that was protecting, or the security protocols that are protecting the data that is resident in everybody's iPhone device, right? So we stood up with the industry and actually put in an amicus curiae brief to say that what Apple was standing for was the right reasons. But you're right, there is a balance that we have to, as an industry, also create between, what is all of these issues around, protecting our customers and their right to, controlling their data, et cetera, and national security and public interest. So, for instance, when there was that horrible terrorist attack that happened in December 2015 in Paris, the moment the and they employed the right routes, the right legal routes to actually make the request. It took Microsoft 45 minutes to actually respond positively, handing over email information about those two terrorists in relation to this Paris attacks. So it is a hard challenge, but I think we have a responsibility to our customers and to society to make sure that we stand up for the principles, not just what we say in our contracts and what we say publicly, but also abide by them when we're having tough conversations against parties like the government.
Thanks. I'd like to take this discussion a little further on ownership of data because that is so important. Sivaram, would you like to give your views on, how is the industry looking at who owns data and what kind of rights can we have over data that we collect from ordinary men and women on the street?
The data is owned by the data subject, right? Who is the owner of the data? The data holder or the data collector should have the right to use for the purpose for which it is taken. Typically like a license, right? A software license, right? You get the rights through the license. But the question which there has been a lot of discussion today on this, the question is what happens to the metadata or the derived data? That's a question. See, that you should be allowing those agencies, data holders to be using that data. But as Kanchan said, with anonymity and if there is a harm indicted to the data subject, the data holder should be accountable. Recently I heard Mr. Nandan Nilangani had proposed a good model. He said there is data at some place and we should be, for the purposes, we should be able to use it. So he had set a model, the data subject would be at the center of this information sharing. Like, I go to a place, they ask me a whole lot of data and I need to get some certificate. I give the consent to take it from wherever my data is held. I think Jio did it, we know. In 3 minutes you get a handset and a connection. What you are doing is you give your right through biometric expression, consent, to take all the data in the Aadhaar. See, we don't know about the other things because the law hasn't come, so whether it will be used only for the purpose, after the purpose is over, whether it will be deleted, all that we don't know. But in my view, he talked about the consent part of it. As Stephen said, we need to have both. The consent part as well as the accountability part. If there is a harm indicted, there is a damage, it has to be indemnified. There is no other way. So both put together, I think one could address, but very, very clear, the data owns with the data subject.
Thank you. Speaking of Aadhaar, we would be remiss if we did not discuss the judgment, although other panels will be discussing it in detail. I do want to speak to Nappinai about one aspect of the privacy judgment on informational privacy, which the Supreme Court said is a facet of the right to privacy. In our online lives, we give away a lot of our data without even knowing we're doing it, and the background to that is the terms and conditions and the privacy policies of various sites and apps will have a very innocuous consent language. Now, we have had very heated discussions about how consent may be redundant, it may be dying, or it may be replaced by other methods. Could you tell us whether consent is still relevant and whether you believe it's an evolving concept today?
Yes. In fact, Rakhi, it's interesting that this question ties into one of the questions that came up in the earlier session. I'd like to address it together. But before we go into that, I thought that one portion of the judgment, which I think is very reminiscent of what we are talking about today, would be nice to elicit here. If I could just read it out. I think this is from the portion where Justice Nariman has given this thing. He's extracting from Felicia Lamport's D-Privacy and says, although we feel unknown, ignored, as unrecorded blanks, take heart. Our vital selves are stored in giant data banks. Our childhoods and maturities, efficiently compiled, our stocks and insecurities all permanently filed, our tastes and our proclivities in gross and in particular our incomes, our activities, both extra and curricular. And such will be our happy state until the day we die, when we'll be snatched up by the great computer in the sky. I thought this was a fantastic way that they have started the whole discussion on information and data privacy. In fact, in my book, I have referred to it in terms of consent as that people today are more happy to say, I agree, than I do, right? We just go out there and click right on there, and we have no time to pause. There is sufficient research which says every person has to read every single terms and conditions. We would need a lifetime. So therefore, when Stephen and others were talking in the earlier session about how consent is technically dead, they're not far off the mark. So to a large extent, today, consent is more a formality or a mere action rather than being informed consent, as Sivaram mentioned, or instructed consent, as I would put it. So when we're talking today about consent being essential, I would say that yes, it's not just consent, it is accountability and consent, and I'm going one step further here and saying responsibility. Because we are also talking about self-regulation here, and that self-regulation has to be a responsible self-regulation. And in doing this, I would like to focus on the question raised more on the aspect of liability. And I would like to tie in the earlier question on artificial intelligence also to this, because everything effectively flows in the same way. The law, the first principles in terms of liability are going to flow through. And that's why I wanted to address the question that was raised earlier about whether conduct or the result decides the liability. I thought that was a fantastic question, because I would like to digress slightly from what Stephen said about harm being a decisive factor with respect to liability. Now, whether it is artificial intelligence or consent, which we are talking about, and possible violation of privacy, the laws that have been evolving, especially in this world of I agrees, the click wraps, is that whilst the contract is binding, it is legal, we cannot shy away from that, but we cannot be bound over to unconscionable or unreasonable terms. And in deciding that unconscionable or unreasonable terms, the decisions do not go into harm as a precondition. It is merely the violation of a right. So I'll give two examples in that. Two of the most shocking violations of privacy were that of the Kayla doll, where there is a global advisory for it to be recalled. Okay, and then the Vizio, the television case. As far as Kayla is concerned, it was a very cute doll. Everybody around the world was happily buying it. It had a chat bot. So there was also this, we all love our new toys, and here is a toy which is also a new toy, right? It's like a bonus. So everybody around the world was happy to buy it for their child. And then they found out that the chat bot was actually having conversations with the child, collecting information about the child, its habits. So when the Supreme Court is talking about us residing in the computer in the sky, it's not just us, it's not just our rights that we are signing away. We are doing it even of children. And this information that was being collected from the children was being used for marketing purposes. The issue that arose was that the same information which is residing in a server could very well become a victim to a hacking and can be misused against all those children whose data is being collected. So there was an advisory. One, there was a recall of the doll, and there have been advisories across the world for destroying the doll or to throw it away and not to continue using it. Where is the consent in this? Right? But to address the issue that you raised. The consent is not even implicit. It's an assumption that because you purchased the doll, you have agreed to use the chatbot, and therefore you're agreeing to anything and everything that the chatbot can do. Where is the harm here? the harm here is merely the violation of privacy of the child. It's not, palpable harm in terms of somebody having misused it or having gone back and done something to a child, etc. So here, that's why I'm digressing from what Stephen said to say, it's not merely palpable harm. It is not damage to somebody through a violation that matters. It is that the violation of the right itself gives you that responsibility. The second case was of Vizio, which had a super smart TV. Sometimes our gadgets think that they're smarter than us, and they probably are too most of the time. Like Sivaram said, we are becoming dumber when we rely more on gadgets, right? So what the TV did was, it was actually capturing expressions of people when they are watching, let's say, a movie or an advertisement, and it was transmitting this back. Why do they need this data about you? They want it because, again, they want to know which advertisement works, which doesn't. So again, I think Kavitha raised a very important aspect of trust. Here is a clear violation of trust, because here is a TV which comes into your drawing room and is actually violating your privacy to the ultimate level. So again, here there is no palpable harm, except that it's a gross violation of your right. So if you look at the catena of judgments on liability, in terms of artificial intelligence, I was really zapped about how we have, taken this forward in the similar way when Sivaram mentioned about how AI may not be able to distinguish between the dark skin to the light skin, etc. That's a very interesting thing that the German guidelines which they have put down.
Sorry to interrupt you, but we're actually running a little short.
Yeah, I'll just finish with this point on how the German guidelines say that, one, the AI is supposed to look at human versus machine, human versus animal, every time the human takes priority. But within humans, if you have to choose, it should not be based on any criteria. Anyway, just taking the whole consent to liability forward, at every stage of liability, what the law states is, if you have a right, if there is a violation, if there is a breach, there will be a liability, irrespective of the fact that you may have waived it or signed it away. Secondly, the take it or leave it concept, saying that this is what my terms are. So forget about signing up itself. If you're saying that if you sign up, you're bound, otherwise don't sign up, that again is not an alternative that you're available with. Facebook, for instance, is facing it on this very basis about data privacy and trust.
Thank you so much. We did have a few more topics that we wanted the panelists to cover, but since I'm being told we only have about 5 minutes left, I would like 10. Okay, maybe we can take a couple more questions. We'd like to talk about the impact of disruptive technologies in the practice of law. Supratim, if you could tell us how have disruptive technologies like AIs and Watson-powered lawyers, if you will, how have they impacted the practice of law?
Okay, so very quickly, in one of my recent lectures in a college, a young student came up and said that, would you really require freshers? Because I heard that machines are drafting the first drafts. So I said, yes, we will do higher things. You guys need to think better on, say, some indemnity concept, how we can better structure it. I was back in office, and there was some service provider who came to us and told us, we are having a particular software which will actually tell you if in your draft you have missed out on something. Maybe you should draft it in a particular manner, which you have missed out. If it's a buy-side share purchase agreement, please ensure that you have taken care of these 5 items. So I was zapped, and I was thinking my comment was maybe already redundant. So yes, so it is actually, like in every sphere, AI is impacting the practice of law. In certain jurisdictions, the judges are being assisted with AI intelligence, and this has also been questioned, Sivaram. There is a very specific case on the point that you made. There was, in Wisconsin, this guy was jailed for 6 years, and it was based on AI software which said that he was a high-risk person. He wanted to challenge it, but unfortunately that opportunity was not given. Later on, there were some news reports that that particular software when, when it was dealt with for a long period of time, there were a lot of issues in relation to convictions against blacks. So, maybe the truth is not out and, the company has completely refuted it, but one cannot rule out that there is a pitfall attached to it. We need to be careful about it. Summarily stating, we cannot rule out human intervention completely. That will be putting us out of business. But yeah, it will be a symbiotic relationship. That's my gut feeling. Thank you.
I just want to give an example of what we're doing at the legal department in Microsoft. We actually use chatbots to sort of, we believe that artificial intelligence is, the purpose of artificial intelligence is to augment the work that humans do and help solve some of the most difficult societal economic problems of the world. The way it's solving it for us at Microsoft Legal is that we've done this ourselves. I mean, there are things that are difficult to do in chatbots, but there are also simpler things that we can do like ourselves. We don't need to be a coder to do it. We have colleagues of ours who have actually created chatbots to take care of their out-of-office replies, where, standardized questions that come to lawyers, say in the context of Microsoft, questions around product marketing policies, questions around code of conduct and ethics policies. These are all there in, text and policies. You don't have to be an incredibly smart lawyer to give responses to this. And the idea is that we want to elevate and do things that are a little bit more strategic. And as a community, as a legal community, we also have to be thinking in that direction. So these chatbots are actually used to respond to simple questions that are being asked by our business clients around these areas. And it's a really interesting way of handling the out of office so you can have a peaceful vacation.
Thank you, that's very interesting. I'd like to quickly discuss a little bit about best practices which companies are adopting in terms of an ethical and a legal use of technology. Kanchan, because ethics is kind of, it differs from culture to culture, it differs from business to business maybe, so how are you seeing companies respond to how ethical they should be in their use of technology, and you have your views on that?
Yeah, so ethics definitely plays a very important part in any of your businesses. I would say that law is just a starting point, but one has to go beyond the letter and spirit, and ethics definitely has to play a very be on a higher pedestal when it comes to handling data, because we are looked upon as service providers, we are looked upon as data custodians. So there is a large amount of trust that the data subjects or our customers are placing on us when it comes to handing over their data to us. So it's important that there is a lot of transparency that is provided when it comes to data handling. So a lot of companies these days are actually, so even when we do our contracts, we are actually trying to give that kind of confidence, be transparent by letting our customers know that, how is it that we are going to utilize their data, how do we plan to secure it, what are the data security measures that are going to be adopted by the company to ensure that we do our best so that the data is not leaked. We have, there are certain companies, who go ahead and adopt some international standards going for certifications so that there are higher standards of security which are applied to data which is within our custody. Because any data leakage can cause a lot of damage not only to the data subject but also to the reputation and the trust that the data subjects would repose on the data custodians.
Blake, as a technologist, would you like to talk about the best practices which companies can adopt?
Yeah, sure. I think these are all amazing discussions we've had and really kind of non-definitive answers to all these topics, right? They're very philosophical and things. In practice, I think all organizations have to start doing is, I like to kind of say you can't replace smart people working on hard problems, but you still have to kind of operationalize doing certain things. What is new, I think, about these new regulations like GDPR from probably prior regulations and legislation is you can't just update your policy with your legal team in the company and kind of check it off and you're done. You actually have to change what you're doing, and you've got to enforce that change across the organization. So to us, it's people, it's process, and it's tools. And what's really interesting about the era now, and this is what OneTrust specializes, is for privacy-specific programs, there are new types of technologies and tools to help you actually operationalize this. So how do I take consent? How do I take documenting what processing activities we're doing, what type of data is being processed by the organization, where are we crossing data transfers across data centers, and tying that process into the way we do contract management with vendors, tying it into doing code reviews as part of an integrated workflow within Jira with our development team as they build new features. All of those things, there's a just beautiful intersection of using new types of technologies to help you do that. So kind of bringing that back to life, I think it's how do you use a set of tools and new technologies to help automate things that you just never had to do at scale. It's tying in your existing teams of smart people, and it's getting kind of alignment with the CISO. I think the CISO takes a very vibrant role in privacy today because they need you to help kind of advocate inside a company to get all the sponsors aligned and the people actually executing on doing what you say you're doing.
Thank you so much. I'd like to open the floor for questions if anyone would like to ask any of the panelists. Is there a mic somewhere? If you could just introduce yourself and indicate who you're addressing the question to.
Hello, I'm Purnima here. I'm a lawyer from Bangalore. My question is essentially to the entire panel. In the light of the fact that Indian literacy levels are so low, how effective is this consent here in India? Because it's very important that most private companies are linking this Aadhaar. Again, I'm coming to the Aadhaar controversy, the data relating to Aadhaar. So what do you think that really the consent means in India? Because when you collect data in India, when a government collects data from private individuals, they think it's as good as we are giving the data to God, especially in the light of the people that the data is going to coming from lower economic sections. So I think this is a very important question we have to address in India.
Would anyone in the panel like to address this?
Purnima, thank you for the question. In fact, I would take it one step further. It's not just about the illiterates that we are talking about, it's about digital illiteracy. Because you may be literate otherwise, you're still possibly digitally illiterate. So the concept of consent and why it is ineffective as the only alternative for data collection is not just because of literacy, but also because of a lack of application of mind in terms of the exercise of giving that consent. Secondly, it's also about the extent to which we are giving that consent without really reading or knowing about it. So I think what you've said about literacy is very important, not just from the government's perspective. And Aadhaar, I'm a strong opponent of Aadhaar, by the way. And I'm not going to get into the topic today because that will be another whole day of it. But one, consent as a process, to consent as an informed consent becomes important. I think the only solution here will be digital literacy and understanding your rights and enforcing it. That may be the only solution.
I had a question in part to the industry representatives and the lawyers. I am Anupama, by the way, and I'm a disputes lawyer in Bangalore. My question is, in light of this push to startup economy that India is focusing on, and really because startups are coming up with so many disruptive technologies of late, I'm wondering about where they fall on the spectrum, because we don't traditionally expect startups to have the same responsibility that larger industries display. Therefore, self-regulation and a sense of social and financial responsibility may not be easily expected of startups. On the other hand, because they're so reliant on external funding, they may be here today, they may be gone tomorrow. Therefore, practically regulation and enforcement of strict compliance requirements, I don't know how practical and effective that will be, because they also have lean teams. They don't have compliance officers, they don't have large teams sitting and ensuring that you're complying with every law across the world. So I really don't understand where startups, fall in this broad spectrum, and how is it possible to practically regulate them?
Sure.
Okay, I think there's already a study which has happened in recent past, how the startups have actually compromised most of our vital data. So there is really a concern, and it's a valid one. As you are aware, after the Supreme Court decision, the government is actually putting together a law which will be soon in place. I think that will be a driving factor to understand its applicability and how it will regulate every player in the market, be it a startup, an established MNC, or the government. But point well taken. I think it's time that it's properly regulated.
So, I mean, in the traditional context of startups, they're creating products, right? I mean, they're creating products, or they're creating like disruptive services. The concept of privacy by design, therefore, in the context of what the Supreme Court's put out there, and the laws that are coming our way that will probably look a lot like what the laws look like in Europe, privacy by design becomes absolutely fundamental in the way startups are thinking about their own products. And it can't be something that's lopped on top of, certain, redundant architecture which is just meant to sort of like tick a box. It actually has to be built into every feature, into the architecture of the product itself. And so the defense of, we don't have enough people to actually sort of oversee this stuff is redundant. I mean, most startups are actually building their applications and their services and their products on the cloud, and actually liaisoning or tying their products in on top of the right cloud stack becomes important, because a lot of the time, these issues around can you create controls and can you create mechanisms in your products and services that will enable all of these consent requirements, that will enable all of these rights of end users in the context of privacy, is something that can be addressed in the context of the cloud itself. Because if you're with the right cloud service provider, they will be compliant off the shelf, essentially. So you have to think of this not just as a response in terms of, do I have enough people overseeing, but do I also have I tied up with the right technologies, and have I tied up with the right service providers who can enable me to comply?
Yeah, and just to kind of extend on that, just from a technology perspective, I think to get on the same point, software today and startups don't so much build new software as it is that they assemble existing components together to some new use case. So that's where I think we are going to see technology move from, you're not building, front-end JavaScript and things like that anymore. Those components now have privacy by design built in. The cloud stack has all these privacy frameworks built into it, and it just will help the industry holistically mature across the board, not only for startups.
One other place where you have startups working are apps. So the App Store, for instance, would have to take responsibility also. And finally, I think it all boils down again to enforcement. If you're able to show that people who have violated laws or regulations have been penalized, that will rein them in, because all the money they are saving by not doing all this and claiming they don't have the infrastructure is going to end up closing the startup itself if they don't start right.
Thank you. Do we have any more questions? One question, I think. Yeah. Thank you.
Hi, I just have a question in terms of artificial home devices. And I think you mentioned about the example that you gave, that just because you buy a device doesn't mean you are subscribing to the fact that you are okay to share your information. So clearly buying the device is not a good enough consent. We spoke about digital literacy, so arguably just kind of agreeing to the terms and conditions is also not a good enough consent. So I would actually like to know your views on what do you think would constitute sufficient consent, especially in the context of artificial home devices or artificial devices like a Google Home or a Facebook Jarvis that we are only going to see increase in the coming days.
Absolutely. I think the threshold level ought to be a practical threshold, of not just like she said, ticking the boxes, not just about signing off or waiving away our rights, etc., but of actually understanding what a device can do. I think Supratim mentioned earlier also about things like Fitbits and health devices. He mentioned it in the context of employers, but let's take it forward to even the context of the companies which are collecting all this data. How many of us really are even aware of the fact that all this data is being collected by somebody and being analyzed and utilized for marketing? So combining all the things which we have discussed, I would say the digital literacy and threshold level for liability, that not just what I would want, but what a lot of cases that have evolved in this field give an indication of, is of consumers knowing what a product can do. What is it actually collecting? Because you know the rule, that if you're getting something for free, then you're the product. If you're buying something, then are you still the product? What is it that you're giving away as that product, right? So, and also finally, when we come to data protection laws, it has to be at a level where it is capable of being enforced. Already, even with respect to the old EU DP provisions and the upcoming GDPR, what I'm hearing is that EU is feeling saturated with respect to data protection. So are we going to do an overkill in data protection in the name of privacy is another issue we'll have to balance out. So we have to balance out, one, awareness and knowledge of the consumer to what they are signing away or what they are allowing to come into their homes or offices, where, or as become part of their lives. And to what extent are they willing to give it away? Knowingly, consciously. I would say that's the threshold that one should probably hope for.
30 seconds, because I couldn't help but jump on. You wouldn't buy, an Amazon Echo if you didn't want it to serve certain purposes, right? Like I want to get up in the morning and say, Alexa, play me my favorite Sunday music. Why is it able to do that and actually play my absolute favorite Sunday music? Is because it has studied my patterns, and to be able to study my patterns and all of the algorithms in the background that's doing that, I have to give it consent. So you're not going to buy. So I want to move away from this fear of not knowing what you're doing, right? I mean, if you don't understand that, unless you're allowing software to understand who you are, it won't serve the purpose that you want it to serve.
I'm glad you mentioned Amazon Echo. I'm just going to take 1 second just to close this loop out. I promise 1 second. So in Arizona, the police asked Amazon to part with information about conversations that a person who was accused of, meaning who was suspected of murder, around the time when the murder happened, they wanted the conversations that Amazon Echo could possibly have recorded at that point of time. So now Amazon refused on the ground that a purchaser of Amazon Echo has a reasonable expectation of privacy of that content which it is recording, and that therefore that reasonable expectation should not be violated. So I thought I would just add on, because you mentioned Amazon Echo. Yes, but the bottom line is, again, that's why I said that it's also the consumer's awareness and willingness to part. I would give another example of location services, right?
So what are we willing to part with, and to what extent are we allowing even the data? See, merely because we have parted with the data doesn't mean we have agreed that it can be used in any which way. So it is both. What are we willing to part with, and what are we willing for that data to be used for?
Thank you so much, and I think that's all we have time for. I'd like to, we've had very interesting discussions and very interesting perspectives were brought out. I'd like to thank each of the panelists for their contribution and the audience as well. Thank you.
A very lovely session indeed. Actually, I'm very happy that before disruptive technologies took over, we all had a childhood. This reminds me of a small joke that I came across somewhere, that I changed my password to INCORRECT, incorrect. I changed my password to incorrect. So whenever I forget what it is, the computer will immediately say your password is incorrect. So these days of artificial intelligence and computing, we have something, life is all not that bad. After so much of food for thought about disruptive technologies, we're going to disrupt your normal thinking further. There's some fabulous Indian and Oriental food that is waiting for all of you. And if there's somebody who's standing between you and the food, it is me. So I'm also going to stop here, but not before calling Nirupama on stage. Can we have Nirupama Nag? Madam, can we have you on stage, please? She's from Aspect Technology. I request her to hand over small mementos to the wonderful panelists. And also one thing, Nappinai has agreed to give away one book as a raffle to the delegates in the evening. So before the beer reception takes over, we'll do that. Thank you, Nappinai, for this.
My pleasure.
Thank you.